Okay, I'm calling the May 22nd, 2013 regular meeting of the Tarpon Springs Board of Adjustment to order. Could we please have roll call?
Chairman King?
Here.
Mr. Cole? Absent. Mr. Hassick?
Here.
Mr. Pavlou?
Yes.
Mr. Tallarino?
Here.
Mr. Darby?
Here. Okay, we'll move on to quasi-judicial announcement and swearing in of speakers, and I'll defer to the board attorney on this.
Yes, the first item, the Joyce appeal, is not a quasi-judicial matter. It is an appeal from an administrative decision. And I want to call your attention to Section 215.01 of the City Code, subsection C, that says the board, in determining whether the administrative official's decision was correct, can only consider the specific code provision considered by the administrative official and the papers, documents, and maps provided to the administrative official before making his decision. The board shall not consider the fairness of the application of the specific code provision in deciding the appeal. So essentially, the issue before you on this is this particular matter is whether the administrative official, I think it were you the administrative official? Yes. Whether Rodney's was correctly interpreted the code. And I know that and I want to descend in the legal gobbledygook, but this is not a de novo decision where you hear evidence and make a decision based upon new evidence or second guess the officials. I mean, the issue is whether the administrative official misinterpreted the code. Now, I know that you have documentation before you and that Mr. Joyce submitted, and I would suggest you view that as like a brief. When there's an appeal in court, what the appellate court has before it is, first of all, the record of the proceedings below, and then briefs presented by the parties arguing based upon the record, you know, whether there was error or whether the court made a mistake in interpreting or applying the law. And then in most instances, the court will also hear oral argument from the parties, again, to explain that. Since this is not, strictly speaking, a legal decision, I think it's appropriate for you to allow public comment. But just be mindful that, you know, what your role here is to determine whether the administrative official, whether Rodney correctly interpreted the code in applying it to this situation. Does that make sense?
Yeah. So what you're saying is that, except for what was considered by the official when making the decision, everything else should just be considered by us in way of deciding what our interpretation of the code is.
Correct.
Okay.
Right. And so I think the proper way to proceed would be to let Rodney explain how he reached the decision, what code provisions he applied, and what he considered. Then let Mr. Joyce argue why, based upon the materials he submitted, Rodney's interpretation is incorrect. And then go to public comment, give them the 3 or 4 minutes, whatever you allow. Then allow any a brief closing arguments or summary, and then proceed in that fashion. But none of it is under oath because none of it is technically testimony or evidence.
Okay. Are we going to go ahead and swear in the people for the
Well, yes.
next petition?
Has the number 2 item been pulled?
Yes, number 2 has been withdrawn.
Okay. Number 2 has been withdrawn. So the third matter on the agenda, or the second thing you'll hear tonight, is a quasi-judicial proceeding. And let me explain for anybody who is here for that a quasi-judicial proceeding is where the Board of Adjustment acts in a quasi-judicial capacity. It's the board's function in a quasi-judicial proceeding to make findings of fact based upon the evidence presented at the hearing, and then apply those findings of fact to previously established criteria contained in the Code of Ordinances to make a legal decision regarding the application. In making its decision, the board may only consider evidence that the law considers competent, substantial, and relevant to the issues, which are essentially the criteria. If that evidence demonstrates that the applicant has met the criteria established in the Code of Ordinances, then the board is required by law to find in favor of the applicant. By the same token, if the evidence demonstrates that the applicant has failed to meet those criteria, then the board is required by law to find against the applicant. The parties to the hearing then would be the applicant and the city is represented by city staff. The procedure that will be followed in the quasi-judicial hearing on, the Yankee Bean application is kind of the same as for an appeal. First of all witnesses in that proceeding must give their testimony under oath, and all persons testifying must give their name and address for the record. All testimony and questioning must address matters that are relevant and material to the issues under consideration. City staff will go first with its case. The applicant will then make its presentation, presenting its evidence and witnesses. The applicant can cross-examine staff, and staff can cross-examine the applicant and any applicant's witnesses. Absent unusual circumstances to be determined by the board, the party's opening statement and presentation should be limited to around 10 minutes. At that point, the board will proceed to the public comment portion of the meeting, where members of the public will have an opportunity to present testimony. They'll first hear from persons opposing the application, and when those people are done, they'll hear from members of the public in support of the application. Each member of the public is limited to, I believe it's 4 minutes of testimony. Following public comment, the applicant and city staff will have an opportunity to make a closing argument or summary and present any rebuttal evidence, with the applicant going first, followed by city staff. Absent unusual circumstances to be determined by the board, the closing statement and summary and rebuttal case should be limited to around 10 minutes. And following that, the board will consider the matter, and at that point they may ask questions of the witnesses. I would ask anyone who intends to testify, which means go to that microphone and say anything on the Yankee Bean matter, to raise your right hand and take the following oath. None of you guys are going to testify? Okay. Okay. All right. Well, if there's a chance that you're going to testify, if you have any thought of testifying, please take the oath now. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. I have affirmations all around. And I guess when we get to that item, we'll ask about ex parte communications.
Okay.
I would ask whether there's been any ex parte communications or contacts on the Joyce matter.
Yes.
Explain.
I was hoping for a better photograph of the fence than what Rodney was able to obtain, because there's trees and shrubs in the way, and Barry Gonzalez recently sold a vacant lot, so I went on his lot, the vacant lot, to try to get a better picture of the fence, and he thought I was the one that was doing four-wheel drive donuts in his property and came out and confronted me, and I told him what it was about, but I didn't really gain any knowledge from him, except he said some nice things about Mr. Joyce being an environmentalist.
Okay. I received an email from Mr. Joyce just from asking if we had received information that he had submitted in our packets. I indicated to him that I was not sure, and but that information is going to be presented by Mr. Joyce this evening.
All right. At this point, I think it would be...
Okay. We're going to move on to, we're going to consider application 1329, Joyce, staff presentation, please.
Thank you, Mr. Chairman. As Mr. Yakavon stated, I will walk you through our process when it comes to fence permits. In this particular case, in about mid-March, we received a building permit application for 66 feet of 6-foot high vinyl fence and 24 feet of 4-foot high vinyl picket fence for the property at 658 Bayshore Drive. These types of permits are what we call over-the-counter permits, similar to a roof permit that is also issued over-the-counter. And what that means is the contractor is normally issued that permit the same day, because the standards for reviewing those types of permits are pretty simple. When it comes to fence permits, what we look for are, does it exceed 4 feet in the required front yard, or does it exceed the 6-foot height limit in the required side and rear yard. And so the permit was forwarded to me. I did the customary checks. You'll see in your backup that particularly those specific code sections dealing with fences are section 36.03, and you have a copy of that in the backup. The Land Development Code also has additional standards for waterfront properties. So properties that are located in the Gulf of Mexico, the Anclote River, all of our tributary bayous, they have additional setbacks or buffers or for structures. That also is the case for wetlands as well, and you have that section. Those standards outlined in section 55.01. You have that in your backup as well. Lastly, what we also have we have a policy in the city's comprehensive plan, which is referenced as policy 1.1.2. And basically what that policy does, while it recognizes that, in this particular case, the 30-foot buffer, what it also goes on to say is it relaxes that buffer in cases, for instance, where you have properties on the sponge docks, and also where you're considering accessory structures, and you see how that is defined in your staff report. And has been the case in the 10 years I've been here that fences do fall under that accessory structure definition. So the permit was signed off and issued. I believe construction commenced, and that's when Mr. Joyce began the conversation with Ms. Vincent on objecting to the issuance of the fence permit. The fence did get a final inspection, and then in about mid-April, Mr. Joyce submitted an application appealing our administrative decision when it comes to application of sections 36.03 and 55.01 as it relates to his neighbor's fence. And you also have a copy of those code sections, the comp plan policy, as well as information that was submitted by Mr. Joyce, stating his reasons for objection. And that concludes my description of the permit review process from the planning department.
Are there any questions for staff?
I want to reserve till later.
Okay. And we have a question right here.
Yeah, just briefly, under K, I get the impression that even a house could encroach on the buffer zone, so easily could that be a 2-story house encroaching on the buffer zone, or does it have to be just accessory structure?
It would have to be. It would have to be an accessory structure, or we have other allowances. For example, pools can encroach, and pool screen enclosures can encroach into that buffer up to 15 feet. So there is an additional exception for that.
Thank you.
Okay. Any other questions? Okay, we will move on to the presentation by the applicant.
I know the rules are to state your name and address. My name is William T. Joyce, and I live at 656 Bayshore Drive in Tarpon Springs. I have some prepared notes. Can you hear me? Is that working? I have some prepared notes to make it easier, so I'm not that much of an ad-lib speaker. Good evening, members of the board. My name is William T. Joyce, and I have lived at 656 Bayshore Drive for the past 16 years. I have enjoyed my waterfront property, which had a full and unobstructed view of Kramer Bayou. I am entitled to this view by law in the Florida State Supreme Court. Then a new owner purchases 658 Bayshore Drive, and they rent the house to a new family. The new owner has never lived in this house and has never spoken to me at 656 Bayshore Drive. Both of these new parties accepted the existing 4-foot-high open chain-link fence, which provided a full, open, and unobstructed view of Kramer Bayou by all of us neighbors. This fence is shown on both property surveys, and it is on the common property line between the two houses. Then on March 20th, you get my other eyes. Then on March 20th, 2013, and without my knowledge, my new neighbors have a fence company come in and replace the existing 4-foot-high open chain-link fence with a 6-foot-high solid white plastic prison-like fence which blocked my water view of Kramer Bayou. If a 4-foot-high fence was installed, it would not block my water view, and we would not all be here tonight. I was not given the courtesy of a consultation on this fence, which has been placed on the common property line between our two houses, and it broke the agreement between the two previous owners of 656 and 658 Bayshore Drive. In fact, I suggested that they replace the existing fence in kind, so there would be no changes or nuisances created that would block the view of Kramer Bayou for the neighborhood. I have provided a full package and photos to the board, including my reasons for this fence permit to be revoked and the common property line restored to its original condition. You as the board are in a position to correct this wrong situation. This case is not about the Land Development Code or the Municipal Code rules, but it is about neighbors and what is the right thing to do in our neighborhood. It is about common sense and common law. A common property line fence should have the agreement of both property owners. In this situation, I did not give approval for a new 6-foot-high fence that makes us incarcerated. In fact, neither my new neighbors nor the city of Tarpon Springs talked to me about approval of this new fence, which showed up and was installed. I was shocked when I lost my views of the waterway and my blood pressure went off the scale. It should be noted that if this 6-foot fence was a variance request, it would fail the 10-point variance test on several counts, including not preserving my enjoyment. This is a neighbor self-created nuisance. No agreement with the adjacent property owner, and this fence diminishes my property value by blocking my water views. One of my witnesses tonight is Goldie Tagarelli, who built and owned both 656 and 658 Bayshore Drive. She will tell you that she had a standing agreement between neighbors to install the existing 4-foot-high open chain-link fence, since it did not block any water views for either neighbor. That agreement holds today until the two new property owners agree to something new, which was not done in this case. Let me ask the board members if they would let their neighbor block their waterfront views with a 6-foot-high fence without their approval. I am certain your answer would be no, and that is also my answer, no. Now, Goldie had church tonight from 6 until 8 o'clock. She said she might be late. But what I did, I don't know if you had a chance to read it. She sent in a support letter for my appeal. I don't know if you all had a chance to read that. Let me just go ahead and read it. It's pretty brief. Dear Mr. Chairman, please be advised that I am Goldie Tagarelli, who is the former owner of 656 Bayshore Drive. I lived in my house for 30 years and I had an agreement with the owner of 658 Bayshore Drive to install a 4-foot-high open chain link fence on our common property line. This open fence gave us a full and open view of the waterfront on Kramer Bayou. I support Mr. Joyce's position that this new 6-foot-high white plastic fence should be removed, as it does not belong in that waterfront neighborhood. My agreement with my former neighbor was for a 4-foot-high fence so we could all see the water. I recently wanted to install a 6-foot fence at my property next to St. Michael's Church, and the city fire department said that I could not install a 6-foot fence because it was a fire hazard and it was to spite my neighbor. This situation is the same as Mr. Joyce's situation, thus the city should be consistent and reject the 6-foot fence installed at 658 Bayshore Drive. Thank you. Signed, Goldie Tagarelli. I also have another witness tonight, Mr. Cliff Martino, who lives on waterfront property on Riverside Drive that is facing Kramer Bayou. He would testify that the city should preserve and protect waterfront views and not permit a 6-foot-high solid fence to go up without the approval of adjacent property owners who share a common property line. When I told him about my situation, he agreed that my property has been damaged without these water views. I think the information that I provided to the board is sufficient to understand how I have lost the full enjoyment of my property without the views of Kramer Bayou. This 6-foot-high solid white fence has created a nuisance for our neighborhood that needs to be corrected. I handed out before the meeting an exhibit that was stapled together. There were 3 things on that exhibit. Goldie's recommendation letter. This is also a letter to the chairman and the board members that, to be quite honest, it didn't show up in my packet. And I was quite surprised because the meat of my appeal is in that letter. So I'll just read it quickly. Here, Mr. Chairman and board members, the Director of Planning and Zoning has approved building permit 13-368, which is a violation of my riparian rights, since this new and higher fence obstructs my view of the Kramer Bayou waterway. This permit approves the removal of an existing 4-foot-high open chain link fence and replaces it with a 6-foot-high, solid, all-white PVC vinyl fence on the common property line between 656 and 658 Bayshore Drive. The waterfront property at 656 Bayshore Drive is owned by the applicant William T. Joyce of Tarpon Springs, and the current absentee owner of 658 Bayshore Drive is James Carras of Massapequa, New York. My appeal to this board is to restore the fences to their original condition, which has existed for the past 42 years without any neighborhood problems. Mr. Carras's new tenants are Tim Duran and Gina Cristofori and 3 children who have moved to Tarpon Springs from Chicago, Illinois. Apparently, they are not happy with the existing 4-foot-high open chain link fences, which have existed for the past 42 years without any problems. The existing chain link fences comply with my legal riparian rights, which require a full and unobstructed view of the waterways on Kramer Bayou. This new fence has created a nuisance and hardship for me due to the loss of my water views.
Mr. Joyce, you have about a minute left if you would just go ahead and wrap it up.
A minute. All right. In this handout,
Y'all will take a look at it.
also the city's presentation, unfortunately they didn't label the photographs. I trust you all knew which views were which. I labeled the photographs on my submittal, direction, address, looking. They did not label them, so if you didn't understand where the photographs were taken, please let me know and I'll go over it this evening. If you look at this picture, this is a 4-foot fence that was put up on the north side of this house. On the south side, they put up a 6-foot fence. As you can see, the 4-foot fence provides a very nice view of the waterway which would satisfy my problems. The 6-foot fence blocks this view. You don't get this view. In closing, I respectfully request that the board revoke this building permit and or take the necessary steps to restore my property and its value to its original condition, which has existed for the past 42 years without any neighborhood problems. The other key thing in my letter, I didn't get a chance to finish my letter, it cut me off, but it's in that package if you have time to read it. There are some flaws in our land development code and muni codes. There's no distinction between waterfront property and upland property. You know, it doesn't take a rocket scientist to explain that the upland property is about a quarter of the cost of the waterfront property. So you have to differentiate. You can't allow a 6-foot fence and somebody that paid for a view, a water view, you can't let that happen. So that's a major flaw in our, and the other flaw is on the buffer zone that you discussed, we all discussed, a seawall, they changed that because of a seawall. It doesn't matter if it's a seawall or a shoreline. They only thought about erosion. It's not erosion, it's riparian rights. Your neighbors have a right to view the waterway.
Okay, thank you, Mr. Joyce.
All right, thank you.
Is there any questions for the applicant?
Mr. Chairman, I think I need to address a couple of issues. Certainly your decision on whether the building official interpreted the code right, but there have been a couple of legal arguments here that I need to render legal advice to you. First of all, riparian rights do not entitle you to an unobstructed view of the entire waterway. Riparian rights, the simplest way to think about this is riparian rights, really back in the day, were the right to wharf out from waterfront property to the nearest navigable channel. So, you know, let's suppose we have 6 lots all on a straight waterfront, and everybody has a riparian rights at right angles to their property out to the navigable channel. But by the same token, I can't build my wharf to cut across another person's property to interfere with his right to wharf out. Well, the same way with view. You have a riparian right to an unobstructed view of that portion of the waterway that comes out from your property, but you don't have a riparian right to in front of another person's property. And first of all, Mr. Joyce, I'm very impressed with your legal research. The first question I asked was, "Are you a lawyer?" But I think he's
engineer, the next best thing.
I think he's misinterpreted the cases. The cases, there's some language in the cases that says where you've got a curving waterfront, so that you don't really have a can draw a perpendicular line. And courts have got to figure out, based upon the orientation of the several properties, where those riparian rights go out. But in no sense does a property owner have a riparian right to an unobstructed view of the entire waterway, to the detriment of the riparian rights of another owner. So if Mr. Joyce's contention were correct, and I had an unobstructed view of the entire waterway, then the next door neighbor who wanted to wharf out to the nearest navigable channel would be interfered with, because his wharf would obstruct the supposed riparian right. Second, there was an argument about an agreement between the parties. Well, I'm not a real estate lawyer, but I think an agreement affecting land has to comply with the statute of frauds, but I'm not going to stake my professional reputation on that. But I do know that an agreement between parties is only effective to the parties unless it constitutes a covenant running with the land, and I don't think there's been any evidence of this. And I'm not aware of any legal principle that a common property line fence should have the agreement of the neighbors. if indeed the contention is that there is some agreement here between the neighbors that prohibits one neighbor from doing something, and that would be a purely private controversy, as long as private controversy not involving the city. You know, the only question here is whether what the person did was consistent, you know, with what our code says. And finally, and I don't know whether this is issue, is that the land development code, and this is well-established law, must always yield to the comp plan. So your land development code cannot be inconsistent with your comp plan. So if your comp plan allows something, but your land development code is vague on it or prohibits it, well, you know, you got the comp plan is superior to the land development code as a matter of law. Those are my only remarks.
Okay, are there any questions for the attorney?
Okay, just so that, excuse me, sir, just so that I'm with you here. After reading all the material, staff has followed the compliance of the land development code.
Well, that's the sole issue here is whether staff has correctly interpreted the code. So I don't want to say that.
There's a word I didn't use, and that's the interpretation of
right.
the land development code. Yeah. And the statement that you just advised the board is that there is no such thing. We can't. Let me see how you say it.
Here's what I was. He was suggesting that his riparian rights, that he has some riparian right that affects this decision. I'm just telling you that that's not my interpretation of the law. That riparian rights don't factor into whether he's interpreted this.
Okay, that's it.
Okay, are there any questions for the applicant?
I have a question for council, staff, city attorney. When we started with this application, this administrative appeal, he told this board to keep in mind that we are to rule based on whether or not staff had interpreted the code correctly when allowing the permit to be issued.
Correct.
So the riparian rights issue, I'm not sure how that is important in our discussion.
And actually, I was thinking that kind of what I said about the contract is true. If indeed one party has interfered with another party's riparian rights, but done something that's lawful under the code, then that once again is a private controversy, not involving the city.
Okay. So it should not be factored into this board's decision then. Okay.
Okay, are there any questions for the attorney? Are there any questions for the applicant?
Thank you all very much. I hope you can appreciate the presentation.
Okay, we will move on to public comment. We will take those speaking in favor of the application first.
My name is Cliff Martino. I live at 471 Riverside Drive in Tarpon Springs. I'm a friend of Bill Joyce. I'm also on the city's historical preservation board. Tarpon Springs is known as a waterfront community. Any blocking of any view, how minor, is concern of all citizens, I would think. My view of the Kramer Bayou is quite a bit different than his. This is out towards the back of his house. Mine is out the front of mine. And I see the whole rear view of all of the other homes on the other side of the bayou. There are a couple fences. Attractive or not, they do cause a distraction of the view. The water is beautiful. The houses are beautiful. Just as most parts of Tarpon Springs are beautiful. Anything that can be done to preserve our open waters on all the bayous and all the rivers and all the waterfront in Tarpon Springs should be preserved. As far as the fence is concerned, when I put up a fence, I went to my neighbors before I put it up, mentioned what I was intending to do, and they had no problem with it. And from a absentee owner, that probably isn't going to happen. From a tenant, that's probably not going to happen. That's basically all I have to say.
One second, does anybody have any questions?
Not for him. I have a staff question.
Thank you very much. Is there anybody else who would like to speak in favor of this application? Okay, now we'll take public comment from people speaking in opposition to the application.
Or Chairman. Probably want to start. My name's Tim Duran. I live next door to Mrs. Joyce at 658 Bay Shore Drive. First, I want to start with the view from my backyard of the fence. It's not a 6-foot fence all the way to the water view. As you can see, it drops down to a 4-foot, which is not obstructing his view from his backyard. I would like to speak. I'm the renter of the property in question, who, along with my wife and children, have been mentioned in the paperwork submitted by Mr. Joyce. I'm only speaking to put on public record and clear the false statements that Mr. Joyce has thrown my family in the middle of this and end his harassment towards us. Mr. Joyce mentions details of what was signed in our lease, in which he has no records of. Mr. Joyce and I have never had a conversation about the fence being unstable and his suggestions with what it should be replaced with. Excuse me. Mr. Joyce also states that our landlord, Mr. Karras, allowed the fence because I paid for it. As a renter, I would not pay that much money for a fence that I'm not taking with me. We are only renters and we did not purchase the fence. The owner, Jim Karras, purchased this fence. He specifically made the decision based on the amount of pile of junk on Mr. Joyce's side of Mr. Karras's, on Mr. Joyce's side. Mr. Karras wanted a 6-foot fence along the house so the junk was no longer visible and an open picket fence closer to the water so no views were disturbed. Mr. Joyce even goes as far as to say that I put the fence up in spite or malice. I have several times started friendly conversations with Mr. Joyce, offered him help while he was doing work in his yard and on his boat. I have even weed whacked Mr. Joyce's yard. There is no spite or malice on our behalf as we did not purchase this fence. Since the fence has gone up, Mr. Joyce has consistently harassed us with profanities in front of my children. This has gone on as recent as this past Sunday, May 19th, 2013, when Mr. Joyce took pictures of my house while my wife and my children were in our bathing suits, having our own private family time. The behavior made my entire family uncomfortable and needs to stop. It is ironic that Mr. Joyce is concerned about his view when his south side is lined up with scrap junk, bushes, and a solid stone wall all the way to the seawall, while ours remains free and clear with open picket fence as submitted by the city of Tarpon Springs. Thank you.
Does anybody have any questions for the speaker? Okay. Thank you very much. Does anybody else want to speak in opposition to this application? Okay, I guess now we can have closing argument from the applicant. If you have anything else you want to add in response to what you've heard.
I disagree with just about everything he said. It was, I'm working in the yard. I see people. Pictures, if you had a chance. Does the board go to visit these properties or no? Just the pictures? Because if you look at his backyard, it looks like a daycare center. I know he only has 3 children, but
I went to visit property.
yeah, I mean, it's, I'm not complaining about anything except you saw the picture of the 4-foot fence. You can see over the fence with 4 feet with a water view, and I think it is spite and malice. Why would he throw up a 6-foot fence on the south side and a 4-foot or no fence on the north side? There's something going on here. I've lived here long enough. Goldie Tagarelli lived there for 42 years. No problems. Now all of a sudden we have a new owner. He's not here tonight because he lives in Massapequa, New York. His tenants are here, obviously, because it's a 5-minute ride. But, you know, I really wish they would consider reducing that 6-foot fence to a 4-foot fence. Because if you walk between the houses, I've never been in prison, but I know what prison feels like with that 6-foot fence. Thank you.
All right. I guess to answer your question, one board member did visit the property, but generally speaking, the board doesn't visit the property before they make these decisions. Okay, staff.
Just briefly, I would just reiterate that our review of this fence permit has been consistent from our department over the last 10 years. You have the code sections and the comp plan there in your backup, and we feel it's clear as what the standards are, and we are confident that the permit was approved per those code standards and the comp plan.
I have a question for staff. I just reading 236-03. I was under the impression that in the city we had some sort of minimum setback. I've heard it said a couple of times that this fence is exactly on the property line.
There are no minimum setbacks for fences. The only regulations are those
right on the property line.
Yes.
Okay. Just want to make sure because it doesn't really speak to whether there's a minimum setback off the property line.
That's correct.
Okay, thank you.
Are there any other questions for staff? All right, discussion?
I got a question. It's just maybe off the wall or something, but is there any differentiation between a fence and a wall?
No, if you look at the title section of 36.03, it's titled Fences, Walls, and Hedges. So those standards will still even comply or be applicable to hedges. So whether it's a hedge or it's a stone wall or a picket fence, the same standards apply.
I have a comment. My comments are, it looks like the city and Rodney did what he was supposed to do and follow the rules. I don't necessarily agree with the rules, but that's not our job here to change the rules. That's the commission. It sounds like we have a civil matter here between two property owners, and my suggestion would be to take it in that direction. I don't think that I can vote for a passage of this application to deny that permit. It seems to me like the city staff has done what the rules tell them to do.
Any other discussion?
No, I would just like to commend the vice chair for making that distinction and being aware of the fact that we are looking at whether or not the permit was done correctly or not, and not taking in this case into account any emotional aspects of who would have to tear down the fence, or whether or not we as members agree with the code as it's written. So I'd like to commend you for that.
Any other discussion? Are there any motions?
Mr. Chair, I move for the, in this case, approval application. Talk to me.
It depends. If you think that Rodney made the right decision, it would be a motion to deny the appeal.
Okay, so is it a motion to deny?
Right.
I have a motion to deny application 1329. Do I have a second?
I second it.
Motion and a second. Vote, please.
Mr. Cole?
Yes.
Mr. Hassick?
Yes.
Mr. Pavlou?
Yes.
Mr. Talarino?
Yes.
Mr. Darby? Oh,
Yes.
we have a full board. Sorry about that.
Okay.
Chairman King?
Yes.
Mr. Darby couldn't vote on that one. I'm sorry. The board was full.
Okay, thank you very much. We will move on to application 1337, applicant Yankee Bean. Staff presentation.
Thank you, Mr. Chairman. This is a variance to reduce the required setback from 5 feet to 2 feet from the adjoining street right-of-way line for a ground-mounted sign. You have the code section in your backup. The location of the property is at 901 South Pinellas Avenue. The applicant's proposal is to install a business sign, and they're asking to reduce the required setback to allow for the installation. As far as review criteria for this application, we have determined that the need for the variance is based on the physical characteristics of the applicant's property. The applicant has operated the Yankee Bean at this location, according to our records, since 2006. The building is L-shaped and contains 2 retail spaces. The retail space closest to Pinellas Avenue blocks the view of the restaurant by northbound vehicles. Furthermore, the restaurant is located in a portion of the building that is approximately 75 feet from the Pinellas Avenue right-of-way line, and installing the sign at the required setback would place it in the parking lot. We have determined that the special conditions associated with the request have not been self-created. We've also determined that the freestanding business sign that is visible to the public is a right that is commonly enjoyed by most all business owners. The minimum request necessary is to grant the 3-foot setback variance. We also determined that it would not extend a special privilege to the applicant, would not have a negative impact on property values, and we have determined it consistent with all of the criteria. We have properly noticed the application and have not received, we have received one inquiry from the public, from Mr. Tim Kafalas. I did forward that correspondence to you. In our estimation, the applicant has met all review criteria. Therefore, the staff recommendation is to approve the applicant's request to reduce the required setback from 5 feet to 2 feet from the adjoining street right-of-way line for a ground-mounted sign located at 901 South Pinellas Avenue. You have a location map in your backup, aerial photograph, a zoning map, a character district map, as well as a brief statement from the applicant outlining their request. Also, I provided you with a boundary survey and a couple of photographs of the building. Are there any questions?
Okay, would the applicant please come forward and give their presentation?
Good evening. My name is Emmanuel Tungranis. I live at 350 Terrace Road, Tarpon Springs. I own and operate the Yankee Bean, located at 901 South Pinellas Avenue. I'm here tonight to respectfully ask this board to grant me a 3-foot variance so I could place a sign to advertise my business that I've had almost 7 years now. Placing the sign without the 3-foot variance would put the sign in the parking lot, which would render it really ineffective, and I would also lose a parking spot. That's about it. I'd be happy to answer any questions.
Okay. Does anybody have any questions for the applicant?
Yes. You agree with the recommendation of staff?
Yes.
Thank you.
Any other questions?
Yeah, I have a question here. I'm looking at this photograph with the letter A on it at the corner of the building. And I also note that for years, or at least I expect for quite a while, there's been a tent sign that sits on the grass, and I see it right here in this, correct?
The A-frame sign, sir? Is that what you're referring to?
Is that where are you trying to put that sign?
Basically, it would be sent. There's a little island right there where the A-frame is at. And
right.
It would be centered in that little island right there, that grass island.
Okay, so that's where the area is?
Yes.
Okay. So it basically would be where that tent sign has been sitting for years?
Yes.
Okay.
Any other questions? Okay, thank you very much.
Thank you.
Is anybody here to speak in favor of this application?
Good evening, Honorable Board, Town Tarpon, 434 Ennis Drive. Here tonight to speak in favor of the applicant. I think for a longtime business owner and resident of the city of Tarpon Springs, I think it would be worthy to show a little bit of goodwill towards him. He's not asking for much. He's asking for a 3-foot setback that he feels would better help advertise his business. I can tell you as a longtime business owner that comes from a family who celebrated our 101st anniversary this year, owning a business in the city of Tarpon Springs, that parking is crucial. So is advertisement and sign placement. And I can tell you that losing a parking space, even though it seems minimal, losing one parking space can be detrimental. So I would be in support of the application tonight. Thank you.
Are there any questions for this speaker? Okay, thank you very much.
Joe Musio, 1319 Gulfview Woods Lane, Tarpon Springs. I am here tonight on behalf of the Yankee Bean to give my support for that 3-foot variance. They are a business here in Tarpon Springs that provide a good lunch and a well-deserved business owners here in Tarpon Springs and longtime family here in Tarpon Springs. And I think with economic times, it's very important the fact that people do know where this business is located. Their store is set back, as Rodney said, about 75 feet. So it really is very difficult to see it from Pinellas Avenue. So with that sign, it will draw new customers to the Yankee Bean. And so, as they said, it's only 3 feet. And again, I believe, if I'm not mistaken, that specific area already had an historic sign years ago. That it had a post and electrical outlet there, and I think it's really grandfathered in, but hopefully the board will approve that 3-foot variance. Thank you.
Any questions? No. Okay. Anybody else here to speak in favor of this application? Anybody here to speak in opposition to the application? Okay, at this point, if you feel it's necessary, you can have a closing argument to add anything. Okay. Does staff have anything to add? Okay, discussion. Is there any discussion of this issue? Okay, do I have a motion?
I move that we approve application 13-37.
I'll second that motion.
I have a motion and a second. Vote, please.
Mr. Cole?
Yes.
Mr. Hafford?
Yes.
Mr. Pavlou?
Yes.
Mr. Talarino?
Yes.
Chairman King?
Yes. Okay, thank you very much. We will move on to staff comments.
I don't have any.
No comments. Board.
I have a comment. I have finished a handout and a presentation on the quasi-judicial process. It's generic in the sense it's not devoted to a specific board, but more of an explanation of the process in your role. There is some debate on the commission whether it should be presented to you individually, in the sense board by board, or whether you can do it all at once and get all the boards together. The other thing that we intend to do is make a DVD or a CD, whatever, something to hand out to you guys, something to hand out to future board members to have that. I don't know what the timing is of the scheduling thing, but my preference would be, and I don't mind repeating myself 5 times over. I'm a lawyer, I'm used to it. But if my preference would be to do it all at once, and then have a question and answer session afterwards, and answer any maybe board specific questions. But I just kind of want to get a sense from you guys how you feel. Whether you would mind having a joint session, if it could be scheduled conveniently.
I wouldn't have an objection to that. Fine.
I think joint session, any session, just as long as we get the training. I think that's the important thing, sooner rather than later.
Okay, well, we're going to try to line that up as soon as we can, and as soon as we...
A couple comments. Thank you for doing that. And a question, do you cover decorum during debate in that at all?
Yes.
Good.
Okay.
And some board comments.
Yeah, we'll move on to board comments, and I know that we have at least one. Go ahead.
Yeah, I'd like to, reading through the section that pertains to the Board of Adjustment, we can make rules. One of the things that concerns me greatly is certain members coming to the Board of Adjustments with their laptop. My concern with that is it could leave the impression with individual applicants, people who speak in favor and against applications, that one board member and the others has access to information maybe the rest of us don't. I think maybe from a standpoint of decorum, I'll ask the city attorney, but I would be in favor of maybe making a rule where we turn off our cell phones and we don't have laptops while we're here in this quasi-judicial setting. So I want to open that up for some discussion.
Well, I certainly think you should turn off cell phones. When I started practicing law, we didn't Actually, when I started practicing law, we had IBM Selectrics and carbon papers and yellow tissues. So computers, per se, and laptops have been in the latter part of my career. And I'm probably the wrong person to ask, because every judge I've appeared in front of federal or state court during the course of a trial, while I'm trying my damnedest to present the best case possible, is sitting there typing on his laptop doing God knows what. I guess my only comment is that I think it's becoming more and more common for, in a paperless world, to have the stuff on a laptop. I guess that would be my only comment. It's up to you.
I guess the question would be, do you think that merely having a laptop, absent anything else, would present an issue that one board member had access to information that other board members did not?
Well, I mean, it's theoretically possible. An applicant would have to somehow demonstrate. That's the whole reason I asked about ex parte communications. To see if there was evidence that the board received outside the hearing, since you're supposed to base your decision on evidence in the hearing. I am not aware of any case where anyone has made an issue over the fact that a board member has a laptop and has notes. They have to prove that you were somehow doing internet research or something, in a digital. So I think the chances are slim, but as I understand the comments, it was directed to perhaps the appearance, and that's going to have to be something you guys will have to judge.
So, and just a question related to your other comment: if the board is motivated, they can make their own rules or some of their own rules. Is that correct?
I think you have the right to make your own rules.
Okay. So, not necessarily rewrite everything, but if the board wants to adopt a rule,
you in fact have rules of procedure. I think.
We do.
Yeah, you do. You have rules of procedure.
And those rules of
procedure.
Can I make a comment?
Sure.
I'm sorry my laptop made anybody uncomfortable. When I go to drug court, which is a lot more serious than this, because people go to prison, they don't have a problem with it. And I did ask Rodney and the city attorney before I used my laptop in the meeting, and they didn't have a problem.
Okay.
I can remember a few years ago, each of the BOC were utilizing the laptops. It got to be nuisance to the individual, not necessarily to one individual in a rest were interested. They agreed, I guess, then at that time to discontinue and go back to the hard paper. I'm not intimidated by computers or an individual on this board utilizing a computer. Matter of fact, I'm impressed because I'm that computer illiterate. But I can understand. I apologize myself on rain tonight. I usually dim that thing so it does not distract from the sitting, from the hearing. But it's an individual thing. It is my opinion would be not necessarily I think, and legal, you hit me if I'm wrong, that we take and make a policy such that an individual who utilizes a computer to do their package is something that we need to make a policy on.
Well, I look at it this way. I can go into state court and bring my cell phone as long as it doesn't ring during trial, and it makes it very convenient for me to step outside and make a phone call. I go to federal court, I can't bring a cell phone in, which makes it very inconvenient. I have to bring a paralegal to run downstairs to use the payphone, or I have to get a special court order. So it's, every court, and you should, because you're kind of like a court, you're quasi-judicial. You have the right to make your own rules of decorum, on how you see fit and, how you think would best be perceived by the public.
Just maybe I'm just off the beat here. What is it really, though, that you have a problem with this pertaining to the computers?
My concern is, we are quasi-judicial, to speak to the city attorney's point, and as such, we need to follow the code and the information, the evidence as it's presented to us in our packets from staff, from the applicants, those in favor and against. My concern for the city is that if you have a 5-member board, one individual with a laptop, the impression could be that that individual has access to data, the other 4 don't. And it's probably, I think it's probably wise that the DOC made their own rule to discontinue the use and go back to paper. So it just speaks to decorum. It speaks to the correct way to handle a meeting. And that's my
correct way of handling the meeting.
Yeah, to make sure that we're not giving the impression, at least to those members in the audience, the applicants, those speaking in favor and against, that one individual potentially has access to data the rest of us aren't using in the quasi-judicial setting.
Do you think it sends a good message that we're green if we're going paperless? Do you think we will want that impression? And do you think that we can control every possible impression?
By we, do you mean our board or the city?
Yeah.
That's more of a political question. I wasn't taking into account whether or not we're sending a message about being green or not being green. I think if I'm coming in front of a judicial setting, in front of a panel, a magistrate, or judges, I pretty much want their attention undivided. To speak with the city attorney, I'm not sure if he's ever been in court where maybe the opposing legal team has had their phone ring while you're making a point, or have you ever had your phone ring and what the judge's reaction was? But
mainly because I don't really know how to use it fully, but I get. Not really bearing. I'm pretty old school. I go to court, and the other side has got paralegals and electronics and stuff, and I buy a paper and stuff. So.
Okay.
What we
I know
that we're going to discuss. We can't really accomplish anything discussing it at length this evening. But let's say that somebody wants to propose a change to the rules similar to what the Board of Commissioners did, so that we can vote on it. And as a board, all of us decide yes or no.
And put it on our agenda.
Yeah, Rodney actually thinks that maybe the decision to discontinue the laptops had to do with technical issues, that they needed an MIS person at every meeting because they couldn't use it. And maybe another suggestion would be to simply to have him announce, or the board, the chairman announce at the beginning of the meeting is that the laptop, that this member simply prefers to have his notes on the laptop, and he's not consistent with the rules he's got to follow. He's not accessing any other information.
Right. I'm not using it for the internet. I'm using it for the seat feature. I can do command F and find exactly what I want.
So that may throw any.
Well, I have no objection to the laptop, but I also have another comment. The laptop sticks up and you can see it. What about if I had an iPad sitting here? Is that going to be against the rules too?
I don't make the rules.
An iPad won't be seen from the. I don't see any reason that we should not be able to have a laptop here. It makes perfect sense to me. If I wasn't so lazy, I would probably have one too. I think.
It makes it a lot easier because I've got the whole code on the computer. I don't have to carry that big binder and the packet.
Okay, do we have any non-computer related comments?
Yeah, I do have another comment. I'd like, if it would please the board, I'd like to have the city attorney explain to us, as a quasi-judicial board, what the correct thing would be as it relates to going out and surveying and investigating applications and properties prior to meetings.
Well, let me say, let me start at the outset. So the quasi-judicial process is a sort of and I don't mean this term offense, sort of a bastardized process between the legislative process and the true judicial process. And so the rules are somewhat relaxed. There are cases that say it is permissible for a member of a quasi-judicial board to go out and look at a property. It's certainly permissible for a member of the board to come in, because I know sometimes you get smaller versions of maps, plats, and diagrams, to come into the city and ask to see the original so that you get a better idea. As long as you disclose you've done that. I think you cross the line when you start to do truly independent investigation in the sense that you go ferret out materials that would not be provided to you. Or, you know, you're not ferreting them out. Someone comes up and gives you materials that they think are binding, that are pertain to an issue, you know, unsolicited, because I've known that to happen. My advice is if you think, for instance, there's some history out there that might be relevant to your decision, or some documents that might be relevant to your decision based upon reviewing the package, you know, my suggestion is you communicate that with your staff member, Rodney, and ask that that be brought to the hearing so it's there. If someone comes up and gives you, you know, an old photograph of Kramer Bayou with a 6-foot fence, you know, then as soon as you can, notify Rodney that you've come into possession of this material so that he can notify the applicant that, look, you know, here something's been submitted, so the applicant has a chance to react to it, and it can be distributed to the board equally, so you all have that. So I guess the distinction I'm making is between it's certainly permissible to look at the property. I certainly wouldn't interview anybody, and I wouldn't try to go out and ferret out information that you know, would not otherwise be provided to you. Again, if you think that there's information, if it occurs to you, you know, I'd really like to know what this place looked like in 1930, to communicate that to Rodney so that he can try to get that information so it's before you to aid in your decision. Is that clarified?
Sort of. I think what I heard you say is it's okay as long as you're not investigating. If you want to go look, is that...
Yeah, you certainly, there's no problem with going and looking at a property. There are cases that say that that's permissible.
So there's cases, it's a case-by-case basis.
No, there are court cases where someone said that looking at the property violates the requirement that your decision must be based upon the evidence at the hearing, and courts have said, no,
right.
A board member can
case law supporting that it's okay.
Yeah, they can go out, you can certainly go out and look at a piece of property, but, you know, there's also case laws that if you receive true ex parte communication that may bear upon the decision that the applicant doesn't know about, or the rest of the board members don't know about, that, you know, the concern would be that you were basing your decision on evidence that no one else has, no one has a chance to rebut or react to.
Mr. Chairman, can I make a comment? Yes. My intention of going out there was trying to see if I could get a better picture, and I would have printed it and presented it to Rodney and the rest of the board if I could have. After I asked if anybody objected to me taking the picture, it was their property. Additionally, when I was out there, I noticed fences that were over 6 feet high. I noticed building code violations on Joyce's property. But I didn't bring pictures of those things into this because that's not part of the discussion. That was not a basis for a decision.
What I would suggest in that situation, okay, that'd be ideal. You go out there, you go, geez, you know, it'd be helpful if we had a current picture of the fence. It'd also be helpful, I think, for the board's decision if we had pictures of other fences. Rather than you take those pictures, suggest to Rodney that it would be helpful. Now, Rodney doesn't have to do that, or the applicant doesn't have to do that. I mean, they get to present their case. You know, that's like they're, you know, the worst thing a trial attorney faces is when the judge goes, "Can I ask questions?"
Exactly.
So he doesn't have. I mean, he doesn't have to do that. But I think in most instances, if you inform staff that there's information that might be helpful to the decision, they'll try to get that. So that way you're avoiding the implication that you're going and getting independent investigation, or you're basing your decision on the fact that you went out there and saw other fences. It was never mentioned during the hearing. You're avoiding that implication, but at the same time, you're trying to assure that that information is before the board to the extent that the other members think it's relevant.
And see, that's where I'm having a hard time distinguishing between going and looking and taking pictures, and to me it just reeks of investigative work.
Right.
And to your point, could you imagine being in front of a judge making your case, and the judge says, "Well, I have my own pictures, and I went there and I interviewed, and it's you against the, you have two investigators."
But I also remember a time when you tried cases that didn't allow jurors to ask questions. This is another thing that I like either.
Can I ask another question?
Yeah.
Is there any other board member that's ever gone out to a property and looked at it or talked with any neighbors?
Okay. I have, when I first started on this board, gone out and viewed a property. If I wasn't totally understanding of my package information, staff made themselves thoroughly available to each board member. If there was a question or concern, then I stopped going out and then I started utilizing staff. When I thought that perhaps maybe I wasn't clearly sure, it didn't look right, it was something I was missing according to the LDC, I would take a ride by. Nothing more than a ride by. At one point, board members that went out to view basically got into a discussion with the applicant, and then there was some information provided to that board member that other board members didn't have to work with. And then I thought that at one point there, and Rodney could correct me, that we went through this, and I think Mr. King, Cameron King was on the board at the time. We went through this process where we, under the new rule, we are not anymore to do that. Based on the information we received, that's how we determined the decision. Based on that, if individual board member had a concern or opinion that they needed addressed, the staff was available to assist in that.
Thank you for volunteering that answer. Has anybody else done that?
Yeah, I have driven by. This is as close as I've ever gotten. I have never knocked on the door, and I don't think I would ever knock on the door and ask. I would never even ask for permission to walk on the property. If I can see it from the street, that's all I would do.
And the law is involved. I mean, I was practicing law when the courts decided, particularly, it started out of land use decisions, when the courts in Florida decided that all land use decisions were not legislative, that when you apply general principles, general law to a particular piece of property, that has to go through a quasi-judicial process. When that first hit, city attorneys, said, "Oh my God," and so we erred on the side of the code of judicial conduct. But over time, the cases have evolved, and so it's not fully fleshed out. But you have a sense that courts have a somewhat relaxed attitude, and there are decisions that not allow you to go view the property. What makes a city attorney very nervous is when a board member says, I went out there and I saw all these other fences, and there's been no evidence about the other fences. At that point, you're transitioning from being a neutral judge to someone who has acquired additional evidence and are injecting that in the proceeding. So, which is why I say, if you go out there and you see something that you think may be relevant, use staff as a way to potentially get that in front of you, all of you, so that you all have it. And that's also primarily the purpose of the ex parte disclosure, is if you disclose an ex parte contact or communication is a bad term, going and visiting or looking at a property is an ex parte thing. If you disclose that, and no one objects to it, and they proceed, and they later try to say, well, that was an ex parte contact. I've got a really good argument in court that you had an opportunity to object and move to recuse, and since you didn't do that, too bad you waived it. So I encourage you to, just be generous in your disclosures of ex parte communications, because maybe once a year, usually when someone's represented by an attorney, does someone actually, make any further inquiries in that. They just tend to let it pass, which makes me feel safer. My primary concern I have two primary concerns. Actually, I have one primary concern. I'm trying to keep you guys from getting sued. So I don't care what your decision is, as long as it's based upon the law and the proper process. So that, other than that, if I do, tell me, I will not inject myself into your decision-making process, other than like tonight to tell you that whether you've been given bad law or something like that.
Can I ask if there's anybody else on the board that's done this?
Done what? Ex parte communication or investigative work?
They just go out and observe a property, look at a property.
No, to me that's investigative work. I've had situations where I've been in social events and people have mentioned that they were going to go in front of the board, and I walk away when I hear that stuff and never communicate directly. But there's a matter of public record. We heard an application, I want to say in October, November, on Kramer Bayou, the other side of Kramer Bayou. And I travel Kramer Bayou all the time. On the record, I mentioned, in fact, I probably got in trouble with staff because I mentioned what a wreck the road. You might remember me saying anybody who's traveled up and down Chesapeake knows what a wreck is. Rodney remembers, he's laughing.
It's fixed now.
It's fixed. I'm sure that endured me to Mr. LaCouris, judging from the last 60 days. But as far as actually going out and taking pictures, investigating, speaking to property owners, no, not here.
And that's a good point. I'm covering part of my talk. You never want to talk to anyone about a matter that's going to come before you. And if people come up to you and start to talk, you need to say, "I'm sorry, I don't mean to be rude, but I can't talk to you about that. I have a quasi-judicial role here that I've got to respect." And because it's those types of things that afford avenues to challenge a decision.
Mr. Yakimon, I know we're running late tonight, but can you tell the board about a cert and certiorari and what would happen if we were drug into court?
Well, first of all, there would be only in rare and unusual, and I've never seen it before in 37 years, cases, is there any issue of individual liability. It would just take, you guys would have to, someone would have to be truly vindictive to have individual liability. The way to challenge an administrative decision is through a petition for writ of certiorari, which has got to be filed within 30 days of the decision. And the court looks at the record and determines three things. A, whether the person was afforded procedural due process. Adequately informed of what the issues were, had an opportunity to address the issues, an opportunity to speak, an opportunity to present witnesses. And as part of that, and that's where the ex parte thing is, if your decision is based on evidence they didn't hear, then you may be violating their procedural due process. The next thing the court determines is whether the proper law was applied. And I can only give you a stupid example. The law is that, you're guilty of running a red light when you go through the light when it's red. But suppose a judge instructs a jury that you can find this person guilty of running a red light if he entered the intersection on a yellow. Well, that's the case where the law has the jury would be applying the wrong law to the case, right? Which is pretty much what I was addressing when I was talking about riparian rights. And then the third thing the judge has to look at is whether the decision was supported by competent substantial evidence. That's a little vaguer as to what exactly is competent substantial evidence. Courts are not supposed to substitute their judgment for the finder of fact as to what the evidence is. And the rules of evidence are relaxed here. But suppose your decision was based completely on hearsay evidence. The court's going to say, well, there was no competent substantial evidence. Or suppose everybody testified yes, there was no testimony no, and you guys decide no. Well, the court's going to look at that and say there was nothing in here to support their decision. However, if 99 people say the light was green and one says it was red, you're entitled as the trier of fact to reject the testimony of 99% of the people and assess credibility and base it upon one person. The jury has the right to believe a witness or not. So what the court is going to look at the evidence, assuming the court's doing its role right, not second guessing you, is going to see is there some evidence in the record that is legally sufficient to support the decision. So those are the three things that courts look at, and that generally is what I am. Whenever I stick my nose in, I'm detecting that there may be a borderline in one of those issues, and I'm trying to steer you back into the right law, the right procedure, or the right evidence.
Okay. I know you've had a long day. Can I ask you one more question?
Sure.
Can there be ex parte communication between board members? Like, say,
No, but that's a violation of the sunshine law. You guys should not talk to each other about anything that may come before you in official capacity and which there's an official decision. Just don't do it. Don't email, don't hire a skywriter, don't go through second people, don't the Goodyear blimp, don't send an email to Rodney and copy everybody else that addresses something that may come before you. Just
Don't do it.
Just don't do it, okay? And then you're not going to violate something.
Thank you.
Any other comments?
Yes, just quickly. Do I understand then that this board will receive training in Robert's Rules, decorum, sometime 60 days, 90 days?
I think within 60 days there'll be. I am not going to address Robert Rules. I find it interesting that the city attorney has always made the parliamentarian, and they don't teach parliamentary law in law school. And I wish Robert had never been born, but I'll address all the other.
Let's just say training period. Next 60 days?
Yeah.
All right.
I think that's fair.
I move that we adjourn for the night.
Oh, okay, good. I have a motion. Do we need to motion that, or can I just? I have a motion that we adjourn this meeting. Do I have a second? Second. All right. Do we have to vote on that? No. Okay, this meeting is adjourned.